start giving explanation to question number 21. One very interesting thing what we found in this year paper, that in some of the questions we can apply elimination rule and easily can get the right or correct option. But this time in some question they have framed the question very differently, where there are pairs given and then you have been asked to identify that how many pairs given are correctly matched. Only one pair, two pairs, three pairs. So there the difficulty is, until and unless you know everything, you will not be able to get the answer. So that you will find in some questions which will follow. So question number 21 is related with polity, constitution, governance. And in this question, 4 statements are given and you have to judge the correctness of these statements. So the first statement is a factual one and it's correct, that it was the H.N. Sanyal committee report on which Contempt of Court Act 1971 was passed. Question number 2, statement number 2, the Constitution of India empowers Supreme Court and High Court to punish for contempt of themselves. This is again a correct statement. I hope all of you must be aware that under Article 129, Supreme Court is the court of records, whereas under Article 215, all high courts are also the court of records, and those which are court of records have the power to punish for their contempt. Okay, so statement 2 is absolutely correct. The statement 3 is wrong. The Constitution of India defines civil contempt and criminal contempt. Nowhere in the Constitution there is definition for civil contempt and criminal contempt. Rather, it is the Contempt of Court Act of 1971 in which explicitly the two terms have been defined. So statement 3 is wrong. Statement 4, that Parliament is vested with the powers to make laws on the contempt of court. That is the reason why the Parliament passed this Contempt of Court Act 1971. So if you can correlate statement 1 and statement 4, you can judge on your own that statement 4 is correct. And therefore, the answer in this question is that statement 3 is wrong and rest all other statements are correct. So the answer is B, Bombay, 1, 2 and 4. Next question, question number 22. Now, this is an interesting question. You will find that different institute may give different answer. And why I am saying this, because even among us, initially there was difference of opinion, but later on there was a consensus that what should be the answer for this question. So when it says first statement, that government law officers and legal firms are recognized as advocates. See, in general, legal firms cannot be recognized as advocates. So in the opening part of this sentence itself, mention of legal firms as recognized as advocates make this statement wrong. So there is no need unnecessarily to get into the complicated tail end part of the statement. Okay, so we will judge that the first statement is wrong. Second statement, bar councils have the power to lay down rules relating to legal education and recognition of law colleges. Now, had instead of bar councils, it would have been Bar Council of India, then this statement would have been correct. Since even in the states we have bar councils, okay, they have nothing to do with legal education regulation and recognition of law colleges. So both the statements in this particular questions are incorrect, and therefore the answer is D, delta.
So in this particular case, the bar councils is the issue. Had it been Bar Council of India, there would not have any problem. So many people have missed out. Even we people missed out in the beginning. Later on we realized that it is bar councils and it is not Bar Council of India. So because of that, bar councils which are present in every state, we cannot, and state bar councils have no role in the legal education and recognition of law colleges. So both the statements are wrong. So neither 1 nor 2. So D should be the answer.
Yes. We will now move to question number 23, again from Polity, and this question relates with Constitutional Amendment Bill. 3 statements are given related with Constitutional Amendment Bill. So the first statement that a bill amending the constitution requires a prior recommendation of the President of India. This is wrong. No prior recommendation for introduction of a constitution amendment bill is required. Any member can introduce, and recently one member introduced one constitutional amendment bill. That can be the reason why this question is there.
Even private members bill can be there, or other private member also can introduce constitutional amendment.
Any member from any house of the two houses of parliament can introduce the constitution amendment bill. So first statement is wrong. Second statement, when a constitution amendment bill is presented to the President of India, it is obligatory for President of India to give his or her assent. This statement is correct. President has no veto power on constitutional amendment bill. Once it is passed by the parliament, both houses of parliament, it is obligatory, it's mandatory for the President to give his or her assent. And you should know one thing, that if President will try to hold assent on constitutional amendment bill which is passed separately by two houses of parliament, it means President is opting for a direct confrontation with parliament, and he is exposing himself to the danger of being impeached. Okay, so that is also one thing which you should know. So statement 2 is correct. Statement 3, a constitution amendment bill must be passed by both the Lok Sabha and Rajya Sabha by a special majority, and there is no provision for joint sitting. So this is a bill where there is a special requirement that this bill should be passed by both the houses separately, and there can never be deadlock or gridlock during the passage of bill between two houses of parliament, and there is no need for joint sitting. So statement 3 is wrong, and a different kind of a special majority is required, so that is something. So statement 2 and 3 correct, statement 1 is wrong. Answer for this is B, Bombay.
And in fact, there is no question of deadlock. If the other house rejects it,
it's an end to the constitution amendment bill.
So
at that stage only the bill will lapse.
Yeah. 24.
Question number 24. Okay. Consider the following. This is an interesting question. Okay, so the first statement says that the Constitution of India classifies ministers into 4 ranks, that is cabinet minister, minister of a state with independent charge, minister of a state, and deputy minister. This classification is not in the scheme of Constitution. In Constitution, you will find cabinet minister, minister of a state, but there is no mention of minister of a state with independent charge. It has emerged as a arrangement to balance between seniority and competency, and most of the time minister of a state, their constitutional status is of minister of a state, but no cabinet minister is appointed above them, and that is why they have to run the ministry independently, and this is the reason why the word minister of a state independent charge. But if you see oaths which are given in Constitution, there is a different oath for cabinet minister, there is a different oath for minister of state. And constitutional status of minister of state with independent charge is no way different than any other minister of state. So first statement is wrong. Second statement, that total number of ministers in union government including the prime minister shall not exceed 15% of the total number of members in the Lok Sabha. This statement is correct. However, this was not in original constitution, but through an amendment in the constitution, an upper cap was prescribed as far as size of council of ministers is concerned, and that upper cap is that it should never exceed 15% of the total strength of the Lok Sabha, including prime minister.
In fact, statement number 1, I just would like to add, most of the places it is mentioned only council of ministers, and only in the 44th Amendment Act we even introduced the term cabinet minister into the constitution. Otherwise, no classification. Everywhere it is mentioned as council of ministers. No classification.
But there is a different oath for cabinet minister and different oath for minister of state. So, okay, so statement 1 incorrect, statement 2 correct. The answer for this question is B, Bombay. Question number 25. Now, this is about exclusive powers of Lok Sabha to ratify the declaration of emergency. Okay, no. Lok Sabha has exclusive power during withdrawal of emergency, not due for ratification of emergency. Now, second statement that to pass a motion of no confidence against Council of Minister, yes, no confidence motion can only be brought in Lok Sabha against the Council of Minister, and if no confidence motion is passed, then it brings an end to the existence or life of the entire Council of Ministers, and this is one of the cardinal principle of parliamentary democracy, where Council of Minister must be collectively responsible towards Lok Sabha. To impeach the President of India, motion is to be passed separately by both the houses of parliament with the special majority, and that special majority is the toughest majority talked under the scheme of Indian Constitution. So the question is about exclusive powers of Lok Sabha. So what I would say that only second statement is what is correct, whereas to ratify declaration of emergency and to impeach the President of India, that will not fall within the ambit of exclusive power of Lok Sabha. So the answer is B, Bombay.
26.
Question number 26. Now, with reference to anti-defection law in India, consider the following statement. Two statements are given, and the first says that the law specifies that nominated legislature cannot join any political party within 6 months of being appointed to the House. Rather, other way around. If they have to join, they must join within 6 months. After 6 months, they cannot join. If they join after 6 months, that can attract, anti-defection law and disqualification. So first statement is wrong. Second statement that the law does not provide any time frame within which the presiding officer has to decide a defection case is absolutely correct. So this is, this is up to it is a prerogative of the presiding officer to take up the case for final decision based on, his availability. Okay, so second statement is correct. First is wrong. The answer for this question is B, Bombay, 2 only.
27.
Next, question number 27.
Attorney General.
Now, there are 2 statements given related with Attorney General. Okay, first statement says Attorney General of India and Solicitor General of India are the only officers of government who are allowed to participate in the meetings of Parliament of India. Now, this statement is wrong because of mention of Solicitor General of India within this. Let me put it like this. Article 76 of Indian Constitution talks about Attorney General, and Attorney General is the only person who, even though is not the member of either house of the Parliament, but can participate during the proceedings of both houses of Parliament with right to speak, but no right to vote. Okay, so Solicitor General is appointed by President to assist Attorney General, and in general, they assist Attorney General by appearing for Government of India in important cases where Attorney General for some reason cannot be present. Okay, so this is because of use of Solicitor General of India in this statement makes this statement wrong. Second statement, according to Constitution of India, the Attorney General of India submits his resignation when government which appointed him resigns. Now, this is not mentioned in Constitution, but this is a tradition. And from where we picked this tradition? From British parliamentary system. But in British parliamentary system, the Attorney General is the part of British cabinet. In India, Attorney General, though is not the part of, cabinet, yet on some occasion he behaves like cabinet member, and what he does that whenever there is change of guard at center, Attorney General will also go and resign, because the provision of the Constitution is that Attorney General holds office during the pleasure of the President. Okay, so this is why second statement is wrong, because it says according to Constitution of India. It's not according to Constitution of India. It is based on tradition or practice. So 1 and 2 both wrong. Answer is neither 1 nor 2. That is D, delta.
28.
Question number 28. With reference to writs issued by courts in India, consider the following. So it is about mandamus and quo warranto, the 2 writs out of 5 which can be issued by Supreme Court and High Court under different articles of Indian Constitution. So first says mandamus will not lie against a private organization unless it is entrusted with a public duty. Now this statement is correct because public duty is a mandatory thing for issuing of the writ of mandamus. Mandamus means what? In Hindi it is known as parmades. You are not doing your duty, so somebody's fundamental rights are being violated. Please do your duty the way you are supposed to do. Okay, so that is what is the nature of this writ. So if a company, private organization is not interested with public duty, how can it lie against them? So first statement absolutely correct. Second statement, mandamus will not lie against a company even though it may be a government company. Now this is wrong. Government company will have the characteristic feature of public authority, and there can be mandamus writ against them, and that is the reason why statement 2 is wrong. Any public minded person can be a petitioner to move court to obtain the writ of quo warranto. Quo warranto means when the court will ask the concerned that what is your authority. Okay, so any person can approach Supreme Court and can ask Supreme Court or High Court that you should ask this public authority that what is his authority with which he or she has done this. So statement 2 is wrong, statement 1 and 3 correct. Answer is C. Calcutta 1 and 3 only. Okay. So there are 4 statements in this question related with Deputy Speaker of the Lok Sabha, and you have to judge the correctness. Okay. And again, for many months now, we are not seeing a Deputy Speaker in our Lok Sabha, and this is the reason why they have asked a question. You have to understand this, that those constitutional offices which are in news for some or other reason, on that they are asking question from Polity. And lot many articles were published for perhaps for the first time in the history of Parliament. We have seen such a long duration in our Lok Sabha where there is no Deputy Speaker. So what is the first statement? As per rules of procedure and conduct of business in the Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. This is absolutely correct. It is the Speaker of the Lok Sabha who has to fix the date for election of the Deputy Speaker. Then the second statement, there is a mandatory provision that the election of candidate as Deputy Speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. No, there is no mandatory provision. There is a practice that the Speaker is from Treasury and Deputy Speaker is from opposition. But many a times we have seen the tradition not being followed whenever the relationship between Treasury and opposition was very hostile.
It is more like a British convention rather than it is a rule. There is no rule, but now we have no Deputy Speaker only. Forget about the rule or anything. The government is not even willing to have a Deputy Speaker in the first place right now. Anyway.
Yes. So the statement 2 is wrong. Statement 3, Deputy Speaker has same power as a Speaker when presiding over the sitting of the House, and no appeal lies against his ruling. This statement is absolutely correct. When he is in chair as presiding officer, he has all powers equivalent to Speaker of the Lok Sabha, and whatever ruling is given by him to keep the House in order, that ruling, there cannot be any appeal against that ruling. So statement 3 is absolutely correct. The statement 4, the well-established parliamentary practice regarding the appointment of Deputy Speaker, that the motion is moved by the Speaker, duly seconded by the Prime Minister. No. Okay. Normally, what we see, that it is Prime Minister who will move the motion which is seconded by the Leader of Opposition, and sometimes we have seen Prime Minister requesting the Leader of Opposition in the House to move the motion which will be seconded by the Prime Minister. So the Speaker has no role as far as moving the motion for appointment of Deputy Speaker. So statement 4 is wrong, statement 2 is wrong, statement 1 and 3 are correct. The answer for this is A.
Yeah, Manish sir can also do this, but it's a easy question. I can also claim, and see the way they placed it. They are also suggesting that it is history.
Yeah, along with history.
Yes. So this is a very simple question, but you have to apply, because see, this was the reason for non-cooperation movement, the division between reserved and transferred subject. And as they were not satisfied with this division, it led to reaction, and this reaction paved the way for non-cooperation movement. And only thing here you can concentrate is local self-government. So local self-government was of course the part of transferred subject, but what you can do without finance, what you can do without administration of justice or police. So they were actually keeping the reserved subject, right? It as a reserved subject. So answer of this question would be C, as they're asking which of the following were treated as reserved subject. It would be 1, 3, and 4. So
Yes.
C would be the right answer.
Number 93, it's a very interesting question about the fifth schedule of the Indian Constitution, and A is the answer. In fact, we have to eliminate. In fact, it says it prevents the transfer of land of tribal people to non-tribal people. Yes, very clearly mentioned. Governor has a role to play in this, and once it's only one of them, so that's very clear. Create local self-governing body. No, that is not mentioned in fifth schedule. Convert area into union territory. Never. And D, the state having such area will be declared special category state. No mention about that. So A is the most appropriate answer in this 93.